5 seconds to go. Start. The offence under Section 3 of the 2002 Act is dependent on illegal gain of property as a result of criminal activity relating to a scheduled offence. Stop. It is concerning the process or activity connected with such property, which constitutes the offence of money laundering. Stop. The authorities under the 2002 Act cannot prosecute any person on notional basis or on the assumption that a scheduled offence has been committed, unless it is so registered with the jurisdictional police and or pending inquiry trial, including by way of criminal complaint before the competent forum. Stop. If the person is finally discharged, acquitted of the scheduled offence or the criminal case against him is quashed by the court of competent jurisdiction, there can be no offence of money laundering against him or anyone claiming such property being the property linked to stated scheduled offence through him. Stop. Para. Section 5 of the 2002 Act is constitutionally valid. Stop. It provides for a balancing arrangement to secure the interests of the person, as also ensures that the proceeds of crime remain available to be dealt with in the manner provided by the 2002 Act. Stop. The procedural safeguards as delineated by us herein above are effective measures to protect the interests of person concerned. Stop. Para. The challenge to the validity of subsection 4 of section 8 of the 2002 Act is also rejected, subject to section 8 being invoked and operated in accordance with the meaning assigned to it herein above. Stop. Para. The challenge to deletion of proviso to subsection 1 of section 17 of the 2002 Act stands rejected. Stop. There are stringent safeguards provided in section 17 and rules framed thereunder. Moreover, the precondition in the proviso to Rule 3.2 of the 2005 rules cannot be read into section 17 after its amendment. Stop. The central government may take necessary corrective steps to obviate confusion caused in that regard. Stop. Para. The challenge to deletion of proviso to subsection 1 of section 18 of the 2002 Act also stands rejected. Stop. There are similar safeguards provided in section 18. Stop. We hold that the amended provision does not suffer from the vice of arbitrariness. Stop. Para. The challenge to the constitutional validity of section 19 of the 2002 Act is also rejected. Stop. There are stringent safeguards provided in section 19. Stop. The provision does not suffer from the vice of arbitrariness. Stop. Para. Section 24 of the 2002 Act has reasonable nexus with the purposes and objects sought to be achieved by the 2002 Act and cannot be regarded as manifestly arbitrary or unconstitutional. Stop. Para. The proviso in clause A of subsection 1 of section 44 of the 2002 Act is to be regarded as directory in nature, and this provision is also read down to mean that the special court may exercise judicial discretion on case-to-case basis. Stop. Para. These transfer petitions are disposed of with liberty to the private parties to pursue the proceedings pending before the High Court. Stop. The contentions, other than dealt with in this judgment, are kept open, to be decided in those proceedings on its own merits. Stop. It would be open to the parties to pursue all other contentions in those proceedings, except the question of validity and interpretation of the concerned provisions already dealt with in this judgment. Stop.